We are now past President Trump's deadline for companies to roll back their diversity, equity, and inclusion programs. A January order gave the federal government 120 days to identify so-called discriminatory DEI practices in the private sector. Trial attorney and legal analyst Robin Nunn is here in Studio 57 to break this down. So what happens next, Robin? I mean, could this lead to investigations or even action against corporations, universities, nonprofits?
Yeah, this is really important. This impacts everyone. Diversity and inclusion is about equality and inclusion for all. And this marks a significant escalation by the federal government in their efforts to roll back DEI initiatives, not just at federal government agencies, but in the private sector now.
Do we know what their definition of discriminatory DEI practices is?
No, that's the tough thing. What's difficult about the executive order is it doesn't define specifically what illegal DEI programs are. So while there have been anti-discrimination programs for years, there was an executive order in 1965 by President Johnson who began these types of DEI programs, and this now removes those coverages.
Because this is a little bit of a gray area, is what I'm hearing you say, do you expect that perhaps those in the private sector who are told by the Trump administration, look, you're using discriminatory practices, will fight this in court?
Well, I think there are going to be three possible, avenues that companies are going to take. There are those who have already begun silently rolling back their DEI programs. Or not silently, or publicly, articulating that they're doing it. There are those who have already come under scrutiny and have been formally asked by the EEOC with sorts of investigations and orders to roll back these programs, and that's being done officially. And then there are going to be those who fight it, and there's going to be litigation. And if some of that litigation is successful, we may see a pushback on these government enforcement programs that are asking that DEI programs be rolled back.
As we've been on the air, we learned the Trump administration is halting Harvard's ability to actually enroll international students. The administration alleges the university is not doing enough to combat anti-Semitism. The school has pushed back on that. But what is the legal precedence for that? What are your initial reactions to this latest move?
Well, I think this dovetails nicely with the topic we were just talking about, because this isn't just about the private sector in terms of large companies. This is also about large nonprofits and universities and colleges. So this pivot towards Harvard and cutting off their foreign programs, I think, is just the natural second wave of action that I think we're going to be seeing by the federal government.
Do we know if there's a precedence for saying you can't enroll any more foreign students and any foreign student has to either withdraw or transfer somewhere else?
I think this is all unprecedented. I think we're in new territory here. We have a new administration, and they're really pushing this agenda.
Robin Nunn, thank you. In a statement to CBS News Boston, Harvard says in part, quote, the government's action is unlawful. We are fully committed to maintaining Harvard's ability to host international students. We are working quickly to provide guidance and support to members of our community.